I'm attorney Mark Nicholson from the Law Office of Mark Nicholson, also known as the Battery Man for my focus on criminal battery cases. Now, today I'm going to talk about Pirtle, Pirtle, Pirtle. The police are demanding to search your car, your home, or your phone. You're in custody, scared and unsure of your rights. This is exactly when Indiana's Pirtle advisements become your legal shield against aggressive police enforcement tactics. If you never heard of Pirtle, listen, you're not alone. But you need to understand this is critical. This is a critical protection, an Indiana-specific legal safeguard that could be the difference between evidence being thrown out of court or you facing serious criminal charges. Now, the legal foundation, your constitutional shield, is this Pirtle advisement. It is a mandatory requirement under Indiana law that forces the police to inform individuals of their right to consult with an attorney before any search. This isn't some optional courtesy. It's the law established by the Indiana Supreme Court landmark case Pirtle v. State. This protection stems from Indiana's Article 1, Section 11 of the Indiana Constitution, which provides stronger protection against unreasonable searches and seizures than even federal law offers. Indiana recognized this. When you're in police custody, the coercive atmosphere makes it nearly impossible to give truly voluntary consent to a search. Here's the bottom line. If you're in custody and police want to search, they must tell you about your right to an attorney first. Now, I'm not talking about if they have a valid search warrant. That's not included. But when police must give you a Pirtle warning, this is when it kicks in two specific conditions. You're in police custody, and that means a reasonable person in your situation would believe you're under arrest or not free to leave. Officers are requesting consent to search your home, vehicle, or other property. Don't let police play word games with you. Custody doesn't mean you have to be formally arrested, sitting in jail, in handcuffs, sitting in a cell. If you reasonably believe you can't leave, if police have drawn weapons, if multiple police officers surrounding you, or if they've told you to stay put, you're likely in custody. Courts look at the totality of circumstances to determine custody. That includes factors like the location of the encounter, the number of officers present, whether weapons are displayed, the tone and language of the officers, whether you're being told you're free to leave or you have to stay there. What searches under Pirtle advisements require? Indiana law is clear. These are weighty instructions into your privacy, and that's when they apply. Home searches, like your residence, when your home is your castle, police know that. Vehicle searches, your car, truck, motorcycle, RV. Cell phone searches, courts have recently extended Pirtle protection to digital devices. However, Pirtle does not apply to these minimal type of intrusions, such as a pat-down, search or frisk, field sobriety tests, DNA checks, drug recognition examinations, DRE. Now, what does that mean? Because police will try to blur the lines. They might conduct a pat-down search that turns into a full search or claim they're just doing a safety check of your vehicle. Know your rights and demand that they be respected. Now, that's the end of part 1. Be sure to look out for part 2. That's your Nicholson Nugget of the day. Please be sure to like and subscribe.